Well, all that we've been waiting for in the Kouri Richards case that we're not going to cover because we already done it. Walking the dog, the letter is being read as we are on the air. Maybe we'll have an update by the end.
Walk the dog. We knew it was going to be a big crescendo. On the other hand, Kelsey Fitz Simmons case, it is just getting, well, it's getting ugly. We've got all the list.
Justice, where are you? Michael and Linda are here.
Love you, Linda.
The world is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
Justice when we see it. To be and down, I lead the way. Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
All righty then. Before I forget, as I've been known to do, thank you to Deborah. Yes, Deborah, for the $25 Venmo. So just doing this so I won't reread it again. Thank you, Deborah.
Yeah, that's great. You got now. I think you really do have gas money to going up and back to Lawrence tomorrow. But before we do that, in our animal segment that I'm trying to do to make us really happy, you don't have to hit the rip and read.
Okay, this is you need to come up with a new animal open of some sort.
Okay, and it's from Instagram, and I haven't been learning how to play Instagram, but you can go look at this. What this is this is a man who jumped in to the frozen pond in Central Park, right? Now, one of the people said that's reporting this, what is New York, that this was one of the coyotes. We have a coyote pair in Central Park called Romeo and Juliet. I don't know about that. Somebody else says it's someone's dog, but he actually jumped into the frozen and again, oh, there we go. We can even play it. Look at this.
Look at that. You're crazy. Wow. And everybody else is watching and recording it.
Right. And, earlier, I looked at some other videos, but this is the one that's clear. Now, whether it's a dog or whether it's a coyote, just watch this for a second, because in all the bad things that we talk about, there are some really good things. Now, I haven't learned what happened to the man. I hope our hero is okay. But look at this. He's got some animal that fell through the ice, right? That's some animal that fell through the ice.
There's something going on there. Yep, there. What? Now he's got it. Is there somebody else in? Oh, I see. So he stayed in until the dog, wolf, or whatever got out. Okay.
And they're going to throw a line to try to get this animal to come out, whether it is Romeo or Juliet, or it's a bigger coyote if it's a coyote.
It looks more wolf, like a big
wolf. Yeah. So, but anyhow, I just wanted to show that to you. I hope he's okay. And quite frankly, I'm not sure that whether it's a coyote or it's a dog, but whatever it is, just fabulous that we have people like this, right, in our community who are willing to put themselves out, endanger their own selves to save an animal.
You always hope that if that presented itself, you would have the whatever it takes, the stones to do it. But you never know. You never know when you're going to be tested. So good for the doggy.
So anyhow, you can go find it on Instagram. No, actually, this was on X. That was an X post, if I recall. So thank you very much. Whoever you are a hero.
All right. So speaking of heroes, wait a minute. Speaking of those that we think of as heroes that maybe are getting tarnished, how about that? This is in the Kelsey Fitz Simmons case, and there's so much that is collateral to the issue itself, which was the shooting on June 30th, that it's getting nasty. There is a hearing tomorrow, of course. We'll be up there for that. It is in Lawrence, Massachusetts, the Superior Court there. Second hearing there in front of Judge Karp. And he had a ruling today, too, which we may get into if we have time. But basically, the short and simple is, remember last time we were there, he took under advisement whether he could adjust the probation conditions, parole or bail conditions, to get rid of the prohibition against Kelsey being with the child, because it's kind of duplicative of what's happening in the family and probate court. He wasn't sure he had the power to do that.
Well, the family and probate court couldn't do anything though because
their
Judge
hands were tied because of the bail
McCarthy
condition.
named him because of the bail conditions, and we
Yeah.
don't even know whatever happened to that. We were supposed to get a ruling about whether Judge Karp is it, and she's gone.
I'm about to tell you.
Oh, I
It
can't wait.
happened
That's why I
today.
can't wait. I can't
It
wait.
happened today. Well, I don't know if you're going to be so happy. He said, "No, I'm not doing anything." He talked to whomever he talked to and came back with a ruling that I'm not going to change those conditions. Of course, everybody is subject to revisiting it with changed circumstances. So that
Yeah,
was.
but what does that tell you about McCarthy naming? Is she in or is she out? Is he like just keeping her conditions, or are her conditions just being still adopted?
Yeah, well, at this point, they're still adopted. He didn't make a change, and he didn't make it sound like I am the grand poobah for any and all purposes. So that was the big issue that was hanging out there. So he just said on that issue, he's not going to touch it. It can be revisited with changed circumstances. If we get a chance, we'll get to that. But we have so much other stuff.
Okay.
As we approach trial on the 23rd, tomorrow, the hearing is really the last pretrial hearing to cover a number of items. So there have been filings by everybody. We went through some of them last night, the motions in limine from both sides. Now we're going to get into some of the Rule 17 goodies that come from the defense. What is Rule 17?
Right. I was going to ask you, what is Rule 17?
That's when you're looking for stuff that is not in the possession of the Commonwealth. If you're the defense, you're looking for stuff not in the possession of the Commonwealth, but otherwise pertinent to, relevant to your case. So some of those third parties, let me zoom in a little bit here.
In other words, you're going to have to send a subpoena or a subpoena to testify, I guess. Or
bring documents or whatever it may be.
Right.
In this case, it is defendant's motion for production of third-party records from the North Andover Police Fire Department. Fire Department. So what are they looking for? You may wonder. They want all records and documentation pertaining to firefighter Justin the Alien of the North Andover Fire Department from January 2020 to the present. And I'm assuming, I don't have the records in front of me, but I'm assuming that's when he began with the department 4, 5, 6 years ago.
Yeah, normally, just even if you ask for documents, if somebody's been long-term, you don't get them except for about 5 years. 5 to 7 years is usually the norm. Sometimes cases will go 10 years if that's the issue. There's a specific issue at heart, but usually 5 years is safe.
And we'll see how this is handled because obviously it's 6 years plus. A, all disciplinary documentation concerning drug or alcohol use in violation of policies, laws, or procedures, including but not limited to positive drug or alcohol tests, disciplinary action for drug or alcohol use in violation of police policies, laws, or procedures, or failure to perform tasks due to substance abuse since his hiring. All delivered materials should be accompanied by an affidavit from the keeper of the records, blah, 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 and sent to the Essex Superior Court, Lawrence. Now, here are the grounds to support the motion. Here's the basic underlying law, the Lapron case, Giglio.
Giglio is a federal case that something goes to the credibility of a witness. You have to produce. It's kind of like Brady in a way, but it's a federal case. Brady is documents that actually show possible innocence. Giglio goes to a witness who may have bias or credibility issues.
And you quite often see those used together.
Right.
So, number 3, before ordering that a summons issue for such records, a judge hearing a Rule 17, which we believe is going to be part of tomorrow's activity, must evaluate those requirements. Party moving for subpoena must produce the documents are evidentiary, that they're relevant, not otherwise procurable in advance of trial, even with the exercise of due diligence, that the party cannot properly prepare for trial without such production and inspection, and that the application is made in good faith, not intended as a general fishing expedition. So this is at least reasonably tailored in terms of specific information requested. You may have a problem with the time frame. That could be whittled down, I suppose, if it had to be. If the court were to say, we'll give you 3 years.
Yeah, but here's my question to you, and it may be answered with paragraph 5. My question to you as counsel, this is a question of whether your client shot Officer Noonan with a deadly weapon. What does all this with Justin have to do with that particular incident up in the bedroom?
Yeah, well, it's all going to relate back to the affidavit and the allegations against Kelsey Fitz Simmons and his abilities to observe, recount issues, events that he's attested to in getting that restraining order and removing the child from Kelsey Fitz Simmons. So it's all the underlying activity that led to the restraining order the day of the shooting. That's what they are.
And I think that's what number 5 is going to say.
Here, the data sought is exculpatory relative to the witness's ability to perceive and recollect, and is reasonably calculated to potentially lead to admissible evidence on the witness. The defense is amply justified in asking for any and all information concerning prior misconduct, drug or alcohol use bearing on ability to perceive or recollect for cross-examination. The documentation is relevant to show that the complainant's accusations are not credible, complainant being Justin the alien, and constitute relevant, powerfully exculpatory evidence. In surveillance video recently returned to the defense team, attached as Exhibit A, representative samples of hundreds of video clips. The witness is seen on camera smoking what appears to be a marijuana pipe or bong hundreds of times. I'm kind of a Pollyanna as it comes to the drug paraphernalia and the use of drugs, so I will defer. And when we look at the video, yes, we will. Everybody can weigh in as they feel appropriate. The information in the records, documentation of drug use and drug testing is not obtainable in any alternative admissible manner, and prior inspection is necessary for a fair trial. The information requested is based on the personal knowledge of the undersigned after viewing the aforementioned surveillance video. Finally, the records sought are not a general fishing expedition into immaterial areas. For the foregoing reasons, the defendant asks the court to authorize the clerk magistrate to issue a Rule 17 subpoena compelling the production of records as listed. Due process, 14th Amendment, 6, Okay, so that's the first of 3 different Rule 17 issues, and I think this would be a good time to take a look at what they are calling Exhibit A. Yes, Exhibit A. So stand by while I fish for, in my own fishing expedition, let me fish for Exhibit A. Stand by.
And while we're doing that, I will tell you that we do not accept trolls in this, okay?
Oh,
And
did you
I'm
see
going to
some
go.
trolling going on?
Yes, I see some trolling
Uh-oh.
going on. Okay, so I am going to put this user, okay? I'm actually going to put this user in a timeout.
Timeout.
Okay? And, go back and go to a Justin-friendly situation. Okay?
Oh, is
Timeout.
there one? Is there
Yeah.
one? Oh, okay.
I don't know.
Maybe that's the PR department reaching out.
No.
Anyway.
Thank you for joining us. Next time,
Thanks.
don't be a troll.
Bye-bye. Okay, here's the backyard. This is April 10, and you'll be lucky there's no audio, so I can't screw that up. Okay, so this is the backyard of the property. There's an individual. I don't think there's any contest as to whom it is. Let me see if it's possible to push in on that particular imagery. You can see he's kind of tucked in beside the house there. Doing something. I don't know. What is that he's doing? Can you decipher that?
Yeah, when you push in, and StreamYard does not let us push in here, you can see that he's smoking something.
Yeah, or if your screen is larger, then we have these little babies to look at. I've just exploded my screen, so yeah, it's pretty clear to me.
Yeah, you can see it. If you expand your screen, you can see it.
Then you can see, it's continually lighting, whatever it is. Again, I'm not an aficionado, but I think that's part of what you have to do. Is that true or not?
I don't know. Look, I shop. Okay, so don't look at me for that. And
that's your drug of choice.
I shop, and I get my marijuana walking in the streets of New York, because if you walk in the streets of New York, you can't avoid but having a secondary marijuana. I'm sure that if you're going to pull my hair, it's going to have it. Lisa Van Cycle says the smoking in a bowl, as we called it back in the 70s. Thank you very much for that.
Yes.
And by the way, before we just go on with that, I am going to answer this. This is Get Wendy. Quit putting Kouri in the title for clickbait. Thank you very much for telling us that. We have Kouri in the title for clickbait because we watch it all day, okay? And that way we can give you a summary of it. But sometimes a case comes along that's more important to discuss, because tomorrow we have this hearing, all right? So we told you the walk the dog letter. We watch it all day. We've been following it. And if you go to our playlist, we have tons of Kouri in our playlist. So quit being a nudge. And if you want to produce the show and give your time to us 24 hours a day, fine, we'll take it. But we're not going to take criticism that's unfounded. So we're going to hide you, and we are going to put you in a timeout. Thank you very much.
And besides, would that actually be clickbait?
No, it's not clickbait.
I don't know why that would be
but
clickbait, even if
it's just somebody it's just somebody who doesn't like us because we're on the side of Kelsey Fitz Simmons.
Oh, well, boo freaking who to you. Okay, so that was April 10, I do believe. Let's see, is there a chance that there are more? Remember, they cited hundreds. We don't have hundreds, but a couple of different options to look at. Remember, there was kind of that little annex part of the house. Looks like an anteroom.
And we don't know. We don't know whether or not who took these. I'm sure that's going to be an issue.
Well, yeah, it's security. It's obviously a security camera just because it has the the timestamp and the location.
Right.
This is now 2 days later. Similar location, it appears. Similar activity, it appears. Why are you hiding? Smoking's a bad habit in general. But why are you hiding? We don't know what he's smoking. We have no idea. But he doesn't want others to know about it, it appears. Curious. Okay. See if I can find another one for you from another angle, just to help give you a sense of that little structure. It's kind of a weird little anteroom that's built onto the side of the house, like a porch, I guess.
Yeah.
Okay, let's move into May. How about May? Yeah, this one, I think this will give you a little different angle here. There's May. So this is inside that little room. Uh-oh, patriotic. That's in, yeah, Justice Search TV now for something completely different. A compliment. Hey. That's funny. Okay, so now he's smoking something inside and blowing it out the window. And I'm thinking, well, this is like May 25. Is it too cold outside? Why aren't you back outside in your corner? That's weird. And for those who think that you can smoke anything inside and nobody will notice because you blow it out the window, you're wrong. Yeah, totally useless effort there, dude. Sorry. I don't care if you're smoking tobacco or heroin or crack, whatever. The smell's still inside the structure. Don't you worry.
You know what this says? This says, you tried, Commonwealth, to dirty up Kelsey yesterday. That's what you tried. Well, here, right back into your face.
Yeah. This is, we believe, Justin the Alien. The images where this person was outside that shed on the backside of the property, much clearer. These actions and the activity is similar, but I would agree that the image is not as clear. Okay, let's see. You get the idea. And there's supposedly hundreds of these videos, all with this sort of activity. Okay.
Yeah. Yeah, so that's really interesting. So I guess they're also asking for drug testing.
You would be surprised, wouldn't you? Let me see if I can
Well,
find
let's
that.
see. Yeah, did I get this right? Because I know you've been doing the work on all this today. While I was watching Kouri Richens.
You were getting ready for clickbait. Let's kind of change tacks a little bit here and look at the parallel case that's underway in the family and probate.
Okay.
court.
All right. Now where's that located? That's not Lawrence.
No. That's not in Lawrence. That is in Salem.
That's another place you've been to, Michael Bryant.
Also Essex County. And Judge Mary Black, who was amazing. She did a great job there the first time we were there. So that kind of activity and custody issues and far more germane to that kind of behavior, much more important. You got somebody taking care of a kid, right? If they've got issues, you probably should ferret that out. To make sure it's not adversely impacting your ability to watch over a child, right?
Right.
Let's see. And we'll have, to support this, we do have Kelsey's declaration, affidavit, they like to call it here in Massachusetts. But this is the actual motion. Ready? Here we go. Okay. Comes down, defendant in the above captioned matter by and through her counsel. The parties, and just basic info, parties never married, have a minor child. Just 1 year old now, by the way, just barely past 1 year old. Mother's 29, father's 31. Parties resided together between March 2024 and June 27. Not on July 3rd, by the way. He wasn't living there. the day of the break-in. On or about June 28, father voluntarily vacated the North Andover home. See his affidavit of care and custody, dated June 30th. So I don't know. I'm sure he was just confused. And then there's a military affidavit that I have not seen showing they lived together as of a few days ago, putting last residing together.
Ooh.
That's another document I was unaware of.
Oh, wow.
In which, so is he lying on the military affidavit?
What's the military affidavit for? Do we know?
Don't know, unless I don't see it referenced or attached here, but maybe it is, and I'm just missing it. Mother's now residing with her mother.
I'm putting our chat.
So find it for us.
I'm putting our chat on this because they're all fabulous, right?
Okay. Mother's now residing with the mother and stepfather in Methuen. Father currently resides with the child at 28 Maple in Stowe, no E, where he lives with his parents. He does not own or rent a home of his own. On or about November 7, 2025, mother sold her home in order to afford legal fees for the two cases that are now consuming her world and to pay for costs associated with her son that she willingly wants to provide. Mother agreed to put $50,000 into an account for the child, from which father withdraws funds to pay for mother's share of the child's uninsured medical costs and agreed upon activities. Footnote here, mother is seeking to move to Newburyport and is asking the Superior Court for approval to do so. The home is a 3-bedroom home with a fenced-in yard, and the lease is for 12 months, which has been paid in advance. So making sure the court knows the child's got a place, stable, a full year is as good as it's going to get under those circumstances.
You know what I love about this, Michael? This is Kelsey and her attorneys, Tim Brady and Martha Coakley, really coming in for bear in now the custody dispute. And they're allowed to get all this out there in front of the jury pool because this is what they wanted to ask for, and now they can't ask for it. She's out on bail. She's in, she's not in jail. She's not in prison. All right, and this is wonderful because there's not a gosh darn thing Justin Alain can do about it, or his mommy dearest mother.
Yeah, and let's not forget the family law attorney. I say that as I forget her name. It's Julie, right?
Right.
I can't remember. Why can't I remember her last name?
Right.
What's her last name? Do you know?
I don't remember her last name either, but she was fabulous.
I can spin to the end of this paperwork, but it's 30 pages long. We'll get to it.
We'll get to the end. We'll get to it at the end.
Okay.
But so there's not a gosh darn thing they can do, and they can't even accuse them of trying to taint the jury pool because she has a right to do this because this baby, she had a right to see, in my opinion, all along the time.
Well, of course. And now the more we're learning, it's more the whole family, the whole alien family teamed up on her and against her. Okay, let's see. On or about sold the home, put the 50 grand in. Said funds were deposited into an account held by father's counsel, and said account is being utilized in that fashion. On June 30th, father was granted a 209A abuse prevention order against mother, as well as full physical and legal custody of the child. It remains in effect, but is set for the first two-party hearing, April 14.
Okay, Kyle Sharkey is here. He says
Kyle's in.
He's in that the military affidavit is in our email inbox. So while you keep going, I'm going to go look. Kyle, you are the best.
Kyle, I don't know. Do you sleep, Kyle? So we'll get a look at that. But I am curious what that's related to. Let's see, where'd I go here? Coming up April 14th. Now, what's happening between now and April 14th that might be of significance?
I get choices?
You could say trial, or trial. Those are your three choices.
Trial. Okay, I'm in for alliteration.
So that will be quite an issue that will be addressed in that April 14 hearing. The next day, from the 30th, on July 1, father filed a complaint for custody support parenting time pursuant to the code. Father amended his 209C complaint on August the 8th. Mother answered the amended complaint on October 22, including her own counterclaim. Paragraph 7. The 209A, while addressing custody, does not mention the mother. I'm sorry, let me start over again. While addressing custody, does not prohibit the mother from seeing communication with or parenting the child. As such, the Essex Probate and Family Court did not view the child as a person to protect for mother, nor did father seek such relief. Nevertheless, There is an Essex Superior Court order preventing mother from direct or indirect contact with the child temporarily, but the parties or this honorable court could modify the same upon a new agreement or order and then obtain approval from the Superior Court. So what they've got is, based on what we just talked about with Judge Karp, he said he's not changing those orders. You have them going against one another here. Now, this suggests either of you can make that change. The probate court can make, family and probate court can make that change, or the Superior Court in the criminal matter, bail conditions could make that change. Somebody do something here. Number 8, mother's criminal defense attorney, Tim Bradle, is arguing on March 12th, that would be tomorrow, in Superior Court for explicit relief from any strictures on the mother being able to freely seek orders. And again, if you read the ruling by the court, it's not closed, it's just not changed yet. Or they could enter into an agreement in the probate and family court, meaning without the need for approval of the Superior Court, in deference to the probate and family court pursuant to AS versus BS. Notably, the judge who issued that stricture is no longer sitting on the case in the Superior Court.
So she is totally removed. They just haven't given that that full order, I guess, that we were waiting for.
Yeah, and I'm going to have to look at his order again to see if he addresses that. I went right to, is he going to make the change or is he not? And he was not.
Right. By the way, I have the military affidavit pages 1 and 2 loaded separately. Thank you, Kyle Sharkey. I just pulled them off our email and put them in, waiting for Michael under PDF.
Oh, okay. So I have them on my side, or you're going to put them?
Yeah. Well, I have them. We can put them up whenever you're ready.
Oh, okay. Let's get to the end of this document,
Yep.
which is a couple more pages. Thus far, the father has been unwilling to agree to any terms whereby the parties, 13-month-old child, can connect with his mother, maternal grandmother, maternal grandfather, or any other maternal family members, other than allowing mother's 17-year-old sister to attend the baptism of the child in January 2026, an event mother begged father not to schedule yet so she could attend, or attend via Zoom, and father refused both requests and scheduled it for January 19, 2026. What do you think of that? Kind of scummy.
Yeah, just a tad. Just a tad.
The limited
I remember the parents can't see the grandparents. They're fighting against the grandparents seeing the kids.
Yeah, they've got a visitation request in there as well, and that's not been heard. But yeah, you have to wonder how deep does the evil go? I mean, why would they want to keep the grandparents from seeing the child, even if you believe everything they say about Kelsey Fitz Simmons? I just don't get it. The limited information mother receives from father about the party's son had to be negotiated by counsel, practically begging for photos or videos of the child every 2 weeks, shared through counsel. You remember that stipulation? We went through that back in, October.
Right. And I'll see if we can we do have a Kelsey Fitz Simmons playlist, and I'll see whether you're going
we definitely talked about it back when it popped. Effectively, this 13-month-old child has been cut off from his mother and her entire side of the family since the age of 4 months old. And there has been no finding that the best interests of this child are being served by ripping his mother and half of his family away from him in this fashion. There is ample evidence of the effects on a newborn child when the mother is ripped from the mother-child relationship, and you've talked about it many times. The motion seeks to end that travesty. On June 30, during the service of the 209A, on mother was shot by a fellow officer of North Andover Police, Patrick Noonan. Mother was immediately transported to Massachusetts General, where she spent 53 days recovering until transported to the Western Massachusetts Regional Women's Correctional Center. We were outside there a couple of nights after she was transferred, having been charged with 1 count of assault by means of a dangerous weapon in the Lawrence District Court on July 3rd. Experienced criminal counsel would refer to this charge as, at best, an entry-level Superior Court charge, rarely justifying indictment on its own, carrying a maximum of 5 years in state prison with a House of Correction alternative, capped at max of 2.5. Here, however, the mother has no record and qualifies under the sentencing guidelines, assault grid level 2 offense in the green, no incarceration zone for 1 year probation if she was ever found guilty. It goes without saying that the mother adamantly denies assaulting anyone with a firearm. Mother's present status is that she is on GPS monitoring. She's able to leave the Methuen home for specific reasons, and it can be included that parenting the child for the appointments or exchanges can be one of those reasons, should parenting outside the home be allowed. 14, mother has the opinion of 2 separate and independent clinicians that she is not a danger to herself or others in the past 9 months. Mother was cleared for returning to duty after a separate assessment was completed. Pretty hard to argue that she's that she's unsafe for others, but here's your gun and badge. Go out and enforce the law. Evaluation data June 11 is available to this court and Father's counsel upon request. The lack of filing the same is an attempt to limit dissemination of a sensitive document, and it will be requested that upon providing the same to this court or counsel, an order issues that prohibits dissemination of the evaluation. As such, mother has a history of being a quality, responsible, careful, and mentally and emotionally competent person to perform her role as a police officer, protect and serve the public, and not a danger to others.
And we've talked about this. She sought immediate treatment for her postpartum depression. I mean, we went back and we played videos from Brooke Shields and all, and talked about all the celebrities who brought it to the forefront that she shouldn't be embarrassed and you get treatment. And that's exactly what she did. She sought treatment for it, and she was cleared after. This is what the tragedy of this whole thing is.
And that's just, it's so hard to be that hypocritical, because one thing, both can't be true. You can't be cleared to have your gun and your badge and go back on duty and be a danger to your child, the father of the child, and others in the community. You can't have it both ways.
But I can see that her whole world came down on her all of a sudden in one fell swoop after she had done everything right. And that does lead to possible people wanting to kill themselves. I mean, we've seen that because that's a whole different issue. That's a whole different issue. And here the true victim is this kid, this poor baby, who doesn't get the bond with its mother, right? These are the most important bonding. It doesn't get the bond with its mother, its grandparents. But when the child gets handed over to court, to Kelsey eventually, and it will, this child will.
Oh, yeah.
I mean, she's going to be foreign to her. And even, there's federal guidelines. Even if you're in prison, you have a right to reunification with your child. You have a right to see your child. Even if you're in prison, courts enforce that all the time. I don't know what the hell Massachusetts is doing.
Yeah, I say that a lot. And if even a part of the things we're hearing about Justin the alien are true, and we've seen videos suggesting issues, is that really the best place for the child? That's in and aside from the fact the child's not with mom.
Yeah,
I'm not sure
the
dad
guy who
is
can
the
take
best
his
place to
brother
be.
and 2 goons with him to break into
Not
his
really
the
great,
mother of his child's house. Really, yeah, great.
Yeah, some judgment issues. On September 16, father filed a motion for temporary orders regarding custody and parenting, uninsured medical costs. We talked about how that's all played out. On October 22, the parties filed a stipulation for temporary orders. Here were the deal: providing father with legal and physical custody of the child, ordering the mother to pay the father, this is not a typo in case you hadn't heard this number before, $12 per week in child
That
support.
was the good judge. I tell you what, that was the great judge, because Justin wanted the whole house held in escrow, offer proceeds, and
He wanted the 200 grand in equity that she was getting.
Right, to support the baby, and the judge said, "Nah, you're going to get $12
How about
a
$50
week,
a month?
you know."
Provided that the $50,000 from the sale of the mother's home located 125 blah 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 shall be held by father's counsel to secure mother's obligation set forth in the stipulation. So there was roughly 200,000 in equity. So 50 of it is accounted for here. Apparently she rented a home, paid up front for a year. That's going to be a pretty good chunk. That's going to be probably 30 to 40,000, depending on the house. Father shall maintain medical insurance for the child if, as, and when the child is no longer covered under the mother's health insurance. The parties shall share equally any and all uninsured medical, dental, therapeutic, and or orthodontic expenses of the child, with the father responsible for the first $250 annually. The parties shall equally share all child care and daycare expenses. Mother prohibited from contacting the father and child pursuant to the 209A, but that the father will twice per month share updates about the child with the mother through counsel. At the time of the October 2025 hearing, mother was held without bail in the Massachusetts Western Regional Women's Correctional Center,
Which you visited, which is way out there.
It's about as far west as you can be and still be in Massachusetts. The significant change in circumstances since that time, and this is why this is key, and we've talked about it all the time. All of these orders are very, rubbery, and as long as you can prove changed circumstances, they can be adjusted. On or about December 23, mother was released from the correctional center on house arrest, awaiting the start of her Superior Court trial on March 23, 26. During the house arrest, mother's conditions in pertinent part are to remain alcohol-free, no weapons, be monitored by SCRAM device, reside with her mother and stepfather at their home, and that she may leave the home for medical and attorney visits. And Exhibit B handling that. Mother's bail conditions and conditions for house arrest do not prohibit her from being with the child at the Methuen residence. 19, mother is therefore hereby, and doing it now, seeking parenting time with the child during her house arrest and after her presumed not guilty verdict at the conclusion of her Superior Court criminal trial. At this point, mother is presumed innocent, and all facts point toward such innocence. As indicated herein, the likelihood of her being sentenced to simple probation, even if found guilty, is extraordinarily high, and this court should consider the same when entering orders as to parenting time, as mother is not likely to face any prison time under the circumstances, which would certainly later affect any parenting time ordered now. The fact that simple probation, even if found guilty, should assist this court in allowing parenting time forthwith and increase that parenting time as the case moves
tomorrow.
forward.
Like whenever this is here, whenever this is on, when is this on for hearing? Like tomorrow.
Well, it's April 14th, but so that was my first thought was, and I really liked Judge Mary Black, who was in charge of this case, and I'm assuming will maintain the case. She could easily say, let's sit on it, let's wait. I realize it's been a long time, it's painful, you have what you need, and you're making an argument, but it's, it's 4 weeks to the hearing in which we're already going to handle all of this. And in the meantime, whether she says this or not, Judge Mary Black, the trial is going to happen, which is going to clear up half of the things that we're talking about here.
Yeah. But
I could see her taking that off ramp.
I love this motion. I love the way Tim Bradle and Martha Coakley have handled this case.
And Julie, don't forget Julie.
And Julie is a bus. Julie's a bus. Was bus her name?
Okay, now I have to zoom to the
now,
end.
of course, you have to zoom to the end and come back, and then
scrolling alert. Scrolling alert.
Because we should look at the military affidavit, and let me explain that they are asking for drug testing, right, for Justin.
Yes.
They want what they call what in
they
the
call
parlance,
hair, right? Hair.
Yeah, they what they're calling they call it a follicle drug test, but that's not really what it is.
Julie Hess.
Hess. I was close. Bus Hess. Right. Julie Hess.
What did you say?
I said bus, but I was close. I knew it was one word. I know.
Okay, all right.
I we're taking the
Julie.
bus to Hess. Okay.
Met you on the courthouse steps. We chatted.
And she didn't really want to talk very much. Okay. But that's what that is it analyzes hair sample. They're not looking for the whole hair. They're looking for like the closest to the root here, right? Which you really can't get when you pull your hair. I'm not going to do it. Okay. But when they take it out, they pull it out, they get the root, right? They start testing from the root, and then it literally you can test the whole hair as long as it is. Like my hair, probably it tests a year, right? 6 months, a year, because about every half inch. And my husband's explained this at lectures a lot. I've heard a lot about this when he had a murder case that one of the first ones they ever did this for, segmental analysis. So for each hair, you can see if I've had coffee. You can see, here we are. Here's the coffee right here. Here's some more coffee. You can see coffee. Probably, I don't know if it detects matcha yet. Coffee, drugs, and go all the way down. They're asking for a follicle drug test, which is the closest 1.5 inch to the scalp. Now, that's why, by the way, you see police officers. It was a real thing in the academy initially. Police officers were shaving their head because they couldn't get drug tests on it, because if you stopped smoking the marijuana, it was out of your system, right? It went out of your system in blood and all, but it stays in this hair. There's this hair. It's like a little spy. Okay, somebody said my hair looked great tonight. I see. Yes. Okay,
maybe you should have it tested.
Well, but the problem is that I probably come back because I'm walking in New York City all the time because I walk in New York City all the time. I'm probably going to come back with some type
I
of
don't know.
marijuana.
That sounds like an alibi. I don't know. Maybe
Yeah,
like
no,
some
no.
weird-
I took one gummy once when it became legal to say, okay, this is supposed to help you sleep. Okay, now because I just was like not into drugs, right?
My dog has had more gummies than I've had.
And then they said, well, if it doesn't do anything, take another. I took a second one. I could barely stand up and walk. It was like down the toilet they went. This was not for me. I mean, this is just it's not my thing. I don't even, as you know, I may drink a glass of champagne once a month, maybe, for you. But this is my crack cocaine right here. Dunkin' Donuts. And as I said, if Robert Kennedy is coming for this, he's going to have to go right through my cold hands. And you know where that comes.
Hands.
Yeah.
I'm just high on life, man. So I don't.
Yeah, me too. I'm high on life. I'm high on family. I'm high on my sister who's not watching today because her cat peed on something. I don't know. It's a long story. It's a long story. It's a family show.
I don't think I want to hear it. Okay, so
yeah, Scott, I'm not a guy. Yeah, I'm not. Even though gummies, I mean, I like the ones that don't have any drugs in them. But boy, that was like, wow.
So anyway, are you sure you're not on gummies at the moment?
No, this is just my natural.
Just you. Okay.
People always see me in court, and they always see me so very staid in court and all. But everybody who knows me knows that I'm not that staid. All right. You have to. You really can't be, because even when you're in court and you're staid, you have to have a connection with the jury, which means you have to have some type of personality. It may not show to the people behind you, but let me tell you, it's showing to the jury. Okay.
So let's whip in that affidavit. Do you have that? Or
yes. Well, you want to pull? Can you pull it? Can you say it's right there?
Where did you send it? Oh, you put it in the.
It's right. Yeah, it's under the PDFs, and that's a PDF. Military affidavit.
I see it. I see it. Let me see.
And then there's the second page.
Is that the first page? Second
that's
page.
The second page. First page.
Stand by. Okay.
There you go.
There we go. Okay.
Thank you,
I don't know if I can manipulate that or not.
I think you can, because it's a PDF, so I think you can. It's
not. I didn't add it to the screen.
Okay, so you want me to try to manipulate
You can
it?
give that a spin if you can.
Give it a spin. Okay. Yeah. I can't.
It's very hard to do when you don't have a separate screen like I have.
I don't know how to give that a spin. Okay. I don't know how to give it a spin. So we're going to have to read it in. Under the, you got that? Under the screen, Service Members Civil Relief Act, Justin the alien, having signed below, affirming to the best of my knowledge that the following statements are true. As of July 1st, 2025, the following parties is not in the military service as defined by in the Service Members Child Relief Act, or Civil Relief Act. Number 2, under C, this is checked.
Okay,
the following parties have concluded the military service as defined in the Service Members Civil Relief Act. Also indicate the exact date the parties have concluded military service. Justin Alain, October 31st, 2019. So now we go to page 2, okay? Because that's all he checked under page 1. Justin Alain versus Kelsey Fitz Simmons. Let's go to page 2. Can you put that up?
I don't know. Let me see. Let me get rid of this. Let's see.
There you go. Okay. All right. You are required to state the fact that support this affidavit, A or B. So let's go to B, because that's what he has checked. I have not used this Service Members Civil Relief Act website to determine the military status of the parties listed in this affidavit. However, the following facts support my statement above as in military status of the parties. You were provided to provide it. And he writes, I have known the defendant for 2 years. She used to work at the North Andover Police Department. We talked every day and lived together as of a few days ago. I was in the military and concluded my service in October 2019. As of a few days ago, they lived together. So on 7/1/2025, which is when he signs this.
So it's written kind of weirdly.
It's written weirdly, but
it should say, until a few days ago.
Yeah, but whatever it is, when he's signing this on 7/1, when was the break-in, Michael?
It's on the break-in was 7/3.
Okay, so on 7/1, he signed this, and they said they lived together a few days ago, but they're not living together anymore in that house. So you had that to the affidavits. And thank you very much. And that's what's also filed in these motions, I gather. So there
All
you
right,
go.
then. Okay. What else you got before I'm trying to decide
No,
what we
keep
should go
going
to
back.
next?
Keep
This thing
going.
is
Keep
this is
going back.
such a long document.
Yeah.
And I'm trying to be somewhat selective here.
I love this. Scott thinks my accent is so cute. It's actually a New Jersey accent, Scott. I'm a Bruce Springsteen girl. I'm from Bruce Springsteen's country. Okay. And by the way, thank you, Karma.
From a Dharma?
Carmel
Oh.
Balsky.
Oh.
Toward half of Michael's coffee tea. Okay. Well, thank you very much. That's
Thank you.
great. That's great. That's more than I give him, and I'm his
True.
streaming
That's
partner.
true. That's true. Okay, let me
Thank you
pick
very
up
much.
here and move forward if we need. Is something still on the docket there? Oh, there we go. Got it. Had to remove one thing and push another thing out of the way. Okay, hold on here. Let's do this. Okay. 22 says, a judge shall consider whether or not the child's present or past living conditions adversely affect his physical, mental, moral, or emotional health. Something I was kind of talking about there. In this case, mother's been primary caregiver to the party's son since birth. At the time she was served with the 209A, the child was only 4 months old. Mother had taken maternity leave during the period of 4 months and 2 weeks while the father worked as a firefighter. Mother was scheduled to return to work on or about July 4. Mother was the parent who woke up with the child, stayed home from work with the child, breastfed him, made the pediatric appointments, attended those appointments, usually with father present too. Threw that in. I appreciate that. Ordered and picked up medications for the child, laid him to sleep at night, rocked him to sleep when he had sleepless nights, and was a fantastic mother to the child by all accounts. Ripping mother away from this child at the age of 4 months is not in this child's best interest, nor in continuing this chasm between mother and child in this fashion. And then go into some of the reasons that we've talked about before, which make it very clear that ain't in the child's best interest.
No,
all kinds
right.
of references to books and treatments and treatises, bonding, how it works, how it doesn't work, what negative issues there can be, including under 18. Severe neglect in infancy can contribute to attachment disorder, anxiety and depression, impaired social functioning. And I mean, some of the things we take for granted, this is from some research done, whether the attachment disruption becomes prolonged. Already at 4 months, the infant recognizes the mother's voice, smell, face, uses the caregiver to regulate distress, and begins forming a pro-attachment relationship. I mean, 4 months, there's a lot that my second granddaughter just turned 4 months. So I envision, if that little baby was removed from mom.
Removed from you and your wife?
Are you kidding me? Yeah,
well, let's
let
remove
alone
from
from
you and
us.
your wife just as grandparents, and then from mom. Are you kidding me? I mean, we've talked about that. I thought that the child should have had visitation with the mother, but they decided for whatever reason, they're the lawyers, that it would not be a good thing. But this is great because remember, this is not in the criminal case. This is in the case dealing with the issue of who gets custody, but this is going to affect the jury pool in the criminal case, and there's not a damn thing anybody can do about it.
Yep, and this gets back to my thought about people, becoming neutral so they can get on a jury.
Right.
I imagine there will be folks who are learning more and more about this situation that wouldn't mind being on the jury.
Right.
So, intended or not, I think it's a consequence that may impact the jury veneer.
Now, before you go, Lisa Van Cycle, Bon Jovi Jersey girl here. You're from Rumsden, along with Bruce Springsteen, so I got a little treat for you. Okay, and it's me with
whip that
Bon
up. Where you just had that
we
standing
went
by?
we had a theater, a charity event. We went with my friend Cece Dyer and my husband and all. So there you go.
Well, look at you with.
I'm sorry. Now you can go. Now you can go back to reading this. We interspersed.
I don't even know where I am.
We try to give our subscribers, our members, people who come here, and we ask you to subscribe, share, like, and notify, and hype, because we try to give you a little bit of our life along with how we view things, so that you have to understand where we come from. Just when we're picking a jury, you want to understand where the jury comes from, and also you understand where we're coming from. That's why we don't take trolls very well.
So I'm just scanning this because it is so we just can't go through the whole thing. I apologize. It'll just take forever. But it's out there, and if you want to invest a little more time than we have to do this tonight, you get the gist of what it's about. And again, this is in the family and probate court, already on calendar for April 14th. Will there be something that happens before that in some sort of emergency petition? If, for example, the trial would end in a way that's favorable to Kelsey Fitz Simmons, would she wait till April 14th? I wouldn't.
I wouldn't. If I'm the judge, first of all, if I'm the parties, if they're not guilty, I'd be there with an immediate emergent application with all this.
So this is we're talking major footnote here, number 3. The Commonwealth filed a motion indicating the police gave father permission to enter. Nothing could be further from the truth. We went through that call. It's out there. Well, I think we're going through it again later this week in the context of jury impanelment. Father called the North Andover police and said he needed to retrieve his belongings at the North Andover residence, despite having no authority to do so. The officer with whom he spoke was under the impression that he resided there and said, well, it's your house, so, I'm assuming, you can make whatever arrangements. There's nothing barring you from returning to your own property. We have no jurisdiction. You may be in stow, from what I understand, but we have no jurisdiction to say what can be removed. The officer asked him if he had been in communication with her family and asked if the family was in the house and indicated if it was his house, then he could enter. Father did not inform the officer that it is not his house. Right. He said he was a resident of that house. He did admit that his name was not on the deed. He did admit that.
And as a matter of fact, we're going to go through that on Friday. We're going to have a premiere show at 6 o'clock where we go through the jury questions and that call, okay? We'll add to our thumbnail at the show, so we're going to go through that. And he also didn't admit that he didn't have the keys, okay? There's a lot of omissions in that house, and it's the transcript you've seen online with someone called Katie. But you won't. We actually co-play that a little bit. Michael and I actually, unlike the Kouri Richards case, where everything except for the walk the dog letter was not read to the jury. All right, we actually have put our own spin on the read of that, and we will put our own spin on the read of that.
Yes, it's a regular Masterpiece Theater.
On Friday. Yeah, I hear that Auntie Deb. Thank you, Auntie Deb gave me a call out. I hope it was great. I'll have to go back and try to find it. If you know what it is. Thank you very much. Oh, nice. And yes, we do allow reasonable trolls. We allow differences of opinion. We just don't allow this kind of assholery that we see sometimes.
There, I've copyrighted that word. Let's see. Let me finish this off here. When the officer indicated she believed he had keys, Father did not correct her, as he clearly did not have keys. Father then called the police again on the 3rd. Father led the police to believe that he resided at the North Andover home. Again, as we will see in the timing on this, we know the break-in from the security tape, 9:30-ish, called to the cops, 10:30, asking if he could do it, an hour after he had done it. Okay.
Yeah, really ridiculous. And thank you, single mama to 4 crazies, a new member. I hope all of you become a member, share, like, subscribe, and all as we're going through this. Thank you very much.
Okay, this is all very interesting. We've gone over it many, many times. Father stole cash, gift cards, mom's passport, personal laptop, other valuables. Remember, he was there to get his belongings. You remember. Then he went and he accessed the accounts, got the $5,000 out, which he says was really his anyway, given to him by a relative.
It was put in the joint account at the time the baby was like born, right? So you know that was a gift. That's what is a gift to both of them. That money was spent, put in January. In June, you don't go back out and take it out in June, okay, or July. You don't go back, take out the $5,000 that was in a joint account. Jesus Christ, excuse me, dear God, for calling your name out. But, you got to help Kelsey here.
And just because you are a joint holder of the account doesn't mean you can do anything and everything. That's not the way a joint account works. A copy, I like this footnote 4, a copy of this surveillance video will be provided to the court upon request. I would be shoving that down their throats. Here, you got to take a look at this video.
Yeah, take a look at it. Absolutely. Scott McGinnis is here, as you know. We gave him a little wrench so we could see him. I consider myself lucky to have gotten to know Michael in person via the Karen Reed trials. What then came was knowing this channel, knowing Linda via all that. So I would have never known 3 years ago. Scott, we love you. You were April 1st when I sat down for the Karen Reed trial with Michael to cover that. And my first time sitting down in this chair, really, to cover that. And there it happened. There you were as a witness to Michael Bryant then becoming a plaintiff and helping getting rid of that buffer zone. I said, and I was on the air to catch it all. We were on the air to record it all. And that was very helpful because it was on our channel and no one could say it didn't happen.
Yep, and it also was helping Mr. Delgado, who had that little sticker ripped from his chest unceremoniously by Massachusetts State Police. Oh, this was interesting. In the context of parents' eligibility for joint custody, the parent who renders cooperation impossible might not be rewarded with sole custody. Interesting. If a judge finds that an irresponsible hostile parent has deliberately stymied attempts by the other parent to participate in the child's life, such a finding may support an award of sole custody to the other parent, where that custodial arrangement will not be detrimental to the child.
Boy,
so instead of helping himself by acting as he had, this may be hurting his chances, the alien's chances of having sole custody.
Oh, even then, this is why, by the way, I like having members in the chat. Darlene Newsley said the actual check was written a year before. I thought it was a 25, but actually a year before. Oh my God.
Yeah, right, and long gone. Yeah, so this, even then, even if it's determined that he has stymied Kelsey Fitz Simmons' attempts, and I think that's clearly what's happening, the court would still allow him some visitation. So, they're not going to foreclose his total in being in touch with the child, which has been happening to Kelsey. We submit the father's actions and his refusal to budge on anything relative to this child and the mother is starting to be a deliberate, hostile attempt to keep mother from the child, not in a protective way, but a controlling way to keep her out of the picture, to never have to pay child support, to receive child support and assistance financially from the mother, while all the while disallowing her to be involved with her only child. While we are not currently seeking sole custody, if things do not improve, and that's interesting, it might be submitted that sole custody should be considered to mother.
Oh, this is what you call, shall we say, I won't say a threat. Okay,
I was going to say throwing down the gauntlet. I was going to say
throwing down the gauntlet to say, look, this is the other side of the law. You wanted a fight. You've now got to fight. And if she gets acquitted, and even if she doesn't get acquitted, because you're not going to do jail time, you have a fight. And again, even if she did get convicted, the whole idea that the feds and all of the jurisdictions have reunification, and you can't stop it. I've seen reunification occur when there's been sexual abuse by an alleged parent on a child, okay? Because that's the game plan, that the child should be able to know the parents no matter how bad they are.
Yep, and it's more about the degree of visitation, custody, than a total lack of.
Right.
Okay, so juxtaposing father's lies, baseless allegations, and obvious illegal activity against mother's conduct, wherein she has never harmed the child, threatened to harm the child, or been under the influence of illegal non-prescription drugs while in the child's presence, it is obvious that mother should at least be allowed to parent her new baby, much less also share in the decision-making with father. Mother is clean, drinks no alcohol, uses no drugs, and is in the care of mental health providers. Notably, father did not even allege mother had done anything to the child in his own affidavit obtaining the 209A, made no threats or a threat to the child, except insofar as he alleged she had punched her own stomach at some point during pregnancy. But clearly, mother did not do that, as the child was born perfect and healthy. On the other hand, father has consistently abused alcohol in the presence of mother and child after birth and on more than one occasion. Mother witnessed father taking non-prescription drugs he received from his cousin and or took from mother's prescription bottles. Oh, nice.
Ooh, now we got theft of a prescription bottle.
There we go.
We've now implicated a cousin. Does the cousin have to take the Fifth Amendment?
Bring on the cousin.
Ooh, bring on Peyton Place. Anyone know about that? Oh, I can't wait.
Yeah.
Ooh, bring the popcorn.
Father regularly
the only problem
smokes.
is that it involves a child, or else I'd be like really happy.
Yes. Father regularly smokes marijuana and drinks during his working hours. Mother recently discovered on the North Andover home's home video surveillance, father's use of marijuana was far more prevalent than she had understood. Yeah, because he's hiding out by the shed or whatever that building was. There are over 100 videos of this use by father, all of which are available upon request. It's like a request show. Now, as I get to this, it reminds me we haven't looked at Kelsey's affidavit,
Okay.
and I want to make sure we do that. I mean, this is just rife with all of this. Based on mother's own observations, father has often possessed drugs and suffers from alcohol addiction. Number 58, father has also stolen pills from mother's Ativan prescription bottle and has done acid in front of the mother. But other than that, father of the year. So,
well, as I said in the past, the one problem I have with Kelsey is that she obviously didn't have good judgment picking him. But you never know what goes on in people's lives, that they feel they need to be loved, and this person can be the person that is loving you. So that's why. Oh, Tubi is barking. I may have to mute if somebody complains.
Tubi is going to get some equal time because Domino was a pain in the butt today. I'm not quite sure what's going on. Okay, so this is Kelsey's affidavit in support of that request. So I'm going to hold on. Let me do some fancy footwork here. Okay. I, Kelsey Fitz Simmons, hereby depose and state under oath. I am a defendant in the above captioned matter and mother of the baby. Justin the alien is the father. Justin and I live together. I owned that home solely and individually. Sold my home November 7th. I have been our son's primary caregiver from his birth until June 30th when Justin served a 209A. Let's see. I took maternity leave to care for our son immediately after his birth, made the appointments, all of those things that we heard her talk about before, and I don't discount any of them. Very important.
Right.
We're just moving through this document. I apologize. Not a single provider has had concerns about my attention or caregiving or safety of my son with me. On December 23rd, I was released on bail from the Western Massachusetts Regional Women's Correctional Center pending a criminal trial. I do not believe it is in the child's best interest for Justin to have sole custody due to Justin's use and abuse of drugs and alcohol, and because I am a loving, competent mother who should be involved with the decisions of our son jointly. I have witnessed Justin obtaining and snorting Adderall. In one such instance, on Christmas Eve 2024, at Justin's parents' house, that's where he lives now.
Oh, now we're going to get mom and dad involved. They're going to say that never happened, right?
When I was pregnant with the baby, Justin obtained Adderall from his cousin, Michael. I saw Justin snort the Adderall through a straw in a bathroom that connects to a kitchen where I was standing. Justin admitted to me that he obtains approximately 10 Adderall pills. I'm about to sneeze. That's why I'm kind of halting. Oh, I think I fought it off. From his cousin Michael every time he sees him, which is approximately 5 times per year. I am prescribed Ativan to treat my anxiety. On at least 15 occasions, Justin would take one of my prescription Ativan pills when he was hungover, or as he believed it would alleviate the symptoms of his hangover. Is that true? Does Ativan help a hangover?
I don't know. You guys in the chat tell me.
Yeah. I witnessed Justin taking acid.
I'm the person who can't take one marijuana gummy to go to sleep. Remember that I had to throw down the
yeah, but maybe you should take some Ativan after you take your gummy. That might help. I witnessed Justin taking acid in the summer of 2024. Unbeknownst to me, Justin kept a tab of acid wrapped in tinfoil in our refrigerator for months. Too bad that, if he still does that, maybe the kid will find that. I mean, it's just...
and I don't say bad things about Justin if he's got some kind of drug issues. Right? Half our population does. It's the scourge of our society. A lot of people have drug issues. The problem you have is that he went after the mom here and all without indicating any issues he may have. And families deal with drug issues and all sorts of issues and still become very good parents all the time. But you can't do what you've done to Kelsey and then say, "Look at me, I'm so clean." All right, that's the problem here, and that's there's
a child involved.
And there's a child involved.
When that happens, I don't give a rip whether you're addicted to something. It's your fault, somebody else's fault. You're a weak person. You have a weak whatever. There's a child involved.
Right.
So I give him far less of that, I guess, sympathy.
I don't have. It's not that I have sympathy for him. I'm saying I don't have animosity for him because of his drug use. All right.
I have animosity because it is impacting the child.
I have animosity because he didn't use his whole self, his true self, to do what he did. That's my
Yeah,
animosity.
I mean, if he wants to spin out of control on his own in an alley somewhere, knock yourself out. Okay. We got past the Adderall.
I'm sorry about
That's
that,
the
guys. but,
Ativan.
you know, we should talk because I don't want anyone in our chat to think we hate them if they've had drug issues, have drug issues, have kids with drug issues.
This
Everybody
is all
does.
in the context of him caring for a little baby.
Right, right.
I witnessed Justin taking acid in the summer of 2024. Oh, that we already got to that. Sorry. I witnessed Justin remove the tinfoil package from the fridge and put it in his mouth. Justin informed me it was acid when I asked him what he was doing. No big deal. Now, I have not taken acid. But I think it's probably not a good thing, just in general.
It was big in the 60s. I remember having to prosecute cases because acid was based on weight.
Yeah, I guess it's making some sort of comeback.
To make it some sort of comeback, based on weight, and there was a question like, well, if you put acid on a postage stamp, it's this amount of in terms of the penalty. But what if you put it on a car? So what does it matter? It should be the weight of the acid, not the weight of the item it's on. I remember that was a big issue back in the 80s when I was prosecuting.
That's very interesting. I like that because that was kind of a thing. They would use stamps. Because who would, who's
and it's making a comeback for treatment of certain types of diseases.
Oh my gosh, how bad is the disease if that's the cure? I've witnessed Justin smoking marijuana, and I've recently come across video surveillance where he smoked marijuana at our home. Yep. Justin told me that he took hallucinogenic mushrooms with his brother, Brendan. Oh, remember him?
Oh, the second one in.
He was number 2 through the door.
Number 2 through the door.
In 2024, Brendan has a civilian position in the Air Force, and he is randomly drug tested. As a result, Brendan does drugs with Justin at the beginning of his trips.
Oh my
usually last 2 weeks when Brendan knows the drugs will be out of his system before his next test. Justin told Mother that he and Brendan microdosed after a getaway in the winter of 2024 and burning the town down. Everybody's going down. Justin is a frequent customer of the Mellow Dispensary in Haverhill. Okay, all right already? Haverhill, Massachusetts. Even though Justin is not permitted to use marijuana products in any form due to his job as a North Andover firefighter, and I did look into that, and it's not just obviously you don't want to be messed up on the job, but they don't even want you using it off the job, even though it's remember, it may be legal under the state laws of Massachusetts, but not under the federal law, and they get federal money at the firehouse.
Right, exactly.
So it kind of blends and blurs those lines. The feds, it's not legal federally, so that could affect the money that the firehouse gets. Let's see. Justin is not permitted to use marijuana products. Justin would often ask me for cash or take money from the ATM so that there was not a financial trail of him buying marijuana. At times, Justin would purchase marijuana from Mellow Dispensary while Mother and the baby were waiting in the car. Mom is so helpful. Mom of Justin.
I think that Mom didn't want Justin marrying, in my opinion, Kelsey, and she wanted to do everything.
But now she has the baby,
and now she has the baby.
Oh, we got your back. Said good job pronouncing Haverhill. Now try. I'm going to say Lemster. I'm going to go with it's Leominstr. Lemster. Tell me if I got that close or not.
Yeah, that sounds like Munster. So Lemster. I'd go with Lemster.
Well, I was basing it on Worcester. I'm kind of using that same approach. Let's see. Justin would typically purchase pre-rolls from Mellow Dispensary. What's that? On Thursday, because the dispensary has a Thursday only deal. Oh, good.
We need a drug correspondent on this show. We need a drug correspondent.
I'm guessing it's already rolled cigarettes. Yeah.
I'm just saying, how people have all sorts of correspondence. We need a drug correspondent.
Justin would also purchase 1/8 of an ounce to grind up and use in a bowl, which may or may not be what we see in the video that we've shown you. 18. I also have serious concerns that Justin is an alcoholic. I've witnessed Justin drinking alcohol almost every night during our relationship, with his beverage of choice being 1 or 2 tall boy Voodoo Ranger beers. Now,
what is that? What's a tall boy Voodoo Ranger beer? Okay.
I stumbled upon this, back in the day, there were like 3 or 4 beers, right? And they all had maybe 3.5%, 4% alcohol content. Pretty normal. Even Guinness, which is an amazing beer, has a very low alcohol content. Voodoo Ranger comes along. A lot of other craft beers and microbrews have increased the level of alcohol content in a beer. Wine is about 15% alcohol, right? So it's a little, that's why you're usually drinking less, by volume of wine compared to beer. It all equals out in terms of alcohol by volume. So here you have a beer, and they sell them in pretty big cans. 9.5% alcohol in these Voodoo Rangers.
Wow,
They're
that
actually
sounds like
very
a lot.
good. They're good, but you got to know what you're getting into. There's a brewery here in Connecticut called Two Roads Brewery. They make an enhanced beer, and it's called Road to Ruin. And it's
Doesn't sound good.
yeah, and then they have one that they put out only in the summer called Rocket to Ruin that has even a higher alcohol. So you just got to know what you're drinking.
The things I have to learn before I cross-examine. These are some things I have to learn. I try to learn.
Yeah,
Whenever
that's
there's a
why.
case, I try to learn things before I have to cross-examine.
Of course,
I did.
you become an expert when you have to handle these things.
Sheila Duffy points out correctly, Michael, that Guinness is not a beer; it's a stout. Okay.
Oh,
even I know that. Thank you,
you.
Sheila.
Thank you. Well, I figure Sheila would know that. And there's nothing like Guinness from the tap in Ireland. Okay, it makes you spoiled for here. I still drink it here, but it's different. Not pasteurized because of all the travel. Anyway, back to voodoo. 1 or 2 nips of Jack Daniels and a root beer flavored McGillicuddy. I am not a fan of that. Don't know what it is. It sounds like one of those foo-foo liqueurs, right? That you drink as a 16-year-old.
The only thing I remember McGillicuddy was Lucille Ball, watching reruns of the Lucille Ball show. Her name was Lucille McGillicuddy.
You're right. Well, you're such a
I'm a trivia
pristine soul.
I like all this trivia.
McGillicuddy. On other instances, Justin would drink a whole bottle of wine. A bottle has about 4 glasses in it. I would obtain at my mother's house after Sunday dinner, which we had weekly. So kind of an interesting ritual. During Christmas of 2024, both my father and stepfather gifted Justin bottles of whiskey. Both bottles were gone in less than 2 weeks. And I recall this because my father came over during that time and asked Justin to share a glass of whiskey, and when he'd given Justin informed my father that the whiskey was gone. I have witnessed Justin's hands shaking on numerous occasions. Justin has told me his hands also shake at work, which he attributes to alcohol withdrawal.
We have war.
He's a firefighter.
This affidavit is World War III. This is more than epic, whatever we're in now. This is like,
This is War of the Roses. And there are lots
goodness.
of thorns. And I'm not done with this part. Are you ready for this?
Yep.
Okay. Alcohol withdrawal, he believes, according to this Kelsey Fitz Simmons affidavit. As a result, Justin has told me that he often needs to drink the cooking wine at the firehouse in order to stop the shaking. While I was pregnant with the child, Justin would drink to excess at every family event or get together we attended, including at our joint bachelorette event. You recall that in Maine.
That's the Jack and Jill party that they try to use against her. So now we're going to find out some real truths here.
There's been them back and forth. Sounds like it was quite the event. At that event, Justin was intoxicated and kept drinking after I went upstairs to sleep. He refused to sleep to keep partying. We got into an argument stemming from Justin wanting to do more drugs. I left hours later to go home without him. On Mother's Day 2025, I took a video of Justin screaming at me. That has not been released yet. Not that I'm aware.
No, it hasn't. And I'd like to know about Michelle at that Jack and Jill party. I wonder what Michelle.
Well, she'll be on the stand. That's going to be interesting.
We can't wait to see this because obviously she didn't tell the whole story if she just said, Kelsey was yelling at Justin.
She was the one out of control.
Right. Yeah. Maybe there's a reason.
Maybe, and maybe there's some jealousy between Michelle and Kelsey regarding Justin the alien. Screaming at me while he was drunk. During the course of that day and as a result of his excessive drinking, Justin fell in the shower, in the bedroom, and while walking up the stairs. So,
remember, he has custody right now of the child, which I really think his mother has custody of the child.
Yeah, I think she's doing the heavy lifting there, which is, again, unfortunate for the baby.
Yeah, I mean, again, the victim in all this is the child. No matter what, it's the child. So, wow, this is the bomb over the ballast. Is that what it is? What do you say?
Back to Guinness real quick with Scott McGinnis. There was a very interesting series on about Guinness and how it evolved and how it became, a fixture of one side of the battle there, the classic battle in Ireland between the Catholics and the Protestants.
Okay.
Very good. Somebody can help me with the name of that show. It was like a 4 or 5-parter. It was House of Guinness, I think. Somebody confirm that for me if they could. Check it out. I don't care whether you have Guinness, had Guinness, hate Guinness. Just a very cool historical perspective and done very well. Just really rich film-like quality to it. So check it out.
So
what Scott say? Guinness is a surname in Ireland. The Mick prefix means son of. So McGinnis, son of Guinness. So you would know that show then, Scott. If you haven't seen that, I'm highly recommending that.
Yeah. It's a stout, not a beer.
I'll have one. Amanda, Amy Forrest. I love Guinness. Yeah. She says it past tense, like you're off the Guinness. You're off the Guinness.
Yeah. So let me put this up again. There you go. See, that's again in case you missed it the first time. I know people's.
Yep. Brushed with greatness. You got it. Okay.
So I mean, we're talking about Jersey peoples here. Bruce Springsteen and people in our chat who are Jersey and understand a New Jersey accent, Actually, I can speak the Queen's English when I choose to, but I don't choose to all the time.
Okay. All right.
All right. What else do we have? What else do we have?
Well, we got more, but I'm exhausted. So
you're exhausted.
We may circle back to some of it at some point.
All right, let's talk about tomorrow because let's talk about tomorrow because I put it on for 9:30, but it's going to be 10. Now the problem is that I won't be.
Bradle's office.
We're going to need somebody to pull that into our stream. The stream is already up as to when it should go. We don't know who's going to be covering it. Are you going to try to apply for?
I'll probably send an email just to have it in place. I don't think I'm going to be the only one, and I think there will be options, and we'll pull in whichever one is really the best.
Well, somebody's going to have to. I'll be on the road, so you're going to have to pull it in. But it's already set up for 9:30, even though apparently the court date has now been moved to 10. The court.
I'm hoping that's correct, but I get that right from Bradle's office, so I'm assuming it's correct.
Correct. So, but we have it in there for 9:30 in case Michael wants to get on. Or do something or whatever. So it may not go up to 10, even though it's there. I mean, there may be nothing till 10.
Yes.
And then he will be there, do some interviews, then rush back home to Connecticut where I will be stationary by 6 and we're going to try to do just a short wrap-up show because I know you're going to have a lot of questions.
Yeah. Oh, yeah. There he is.
Okay, there he is.
Back. Are you back?
Yes.
What a pest you are today. What is your deal? I don't understand.
Yeah,
people now say, Domino's not a pet.
Well,
leave that dog alone.
Yeah, he's adorable. What are you talking about? Look at that. Look at that face. Look at that face.
Okay? Look at that. Look at that.
Here, look at that face. And then look at this face. And then look at both of these faces. This is why we sometimes do our little animal thing that we try to intersperse all the horrible stuff that we see with all the good stuff. Anybody who wants to tell me about the shout out Aunt Deb gave me, just send a text to justiceservetv@gmail.com.
The time code.
Okay. Give me the time code. Yeah, I'll look at it. I will be on the road traveling also tomorrow. So it's kind of a little loose. As I said, we have the thumbnail set up. We have the ability to pull something set up. But whether we're successful at it, I'm not too sure.
It's a crapshoot.
But anyway, we definitely will be live at 6 for all of you.
That's right.
Any questions? Also send them to @JusticeServeTV or to JusticeServeTV.
To our mods that tomorrow.
Who
knows what's going to happen?
And we thank you all for your comments. We thank you all for your donations, which with the way gas prices have gone up because of the greed of the gas company.
Corporate greed.
Right now, we would like to, hopefully, Michael's going to take the moving studio, right? The mobile studio.
I'm taking the mobile studio. Yes.
I'm taking the mobile studio.
The Starlink, the new and improved Starlink.
Right, the new and improved Starlink.
Courthouse is right by a big open park.
V39 was the shout out. Carmel Volsky. I'm not pronouncing your name right, and I don't like that. I hate when I mispronounce names. Okay. Thank you. Crumbs 937 gifted 5 Justice Serve TV memberships. Thank you
so
very
well.
much. We didn't do a members only this week because we've been so busy with all this. We'll try to get back to that next week. And I will get back to, you got to all help us find the killer of Stephanie Vilko.
Oh my gosh, yeah.
There's been so much going on, and all of you have been so busy with all of these cases and that we see, so and then I next week, not this coming week, but the following week on the 23rd and 24th, I will not be here to help Michael because I have a federal case of my own that I'll be dealing with all lawyers flying in on Monday for a huge mediation on Tuesday. And so I won't be back until Wednesday. So I need all of you to really help Michael. Maybe he'll have a guest co-host to help you.
Yeah, we'll figure it out. See what happens then. We'll see. So
one of these days,
let's get through tomorrow.
One of these days, I'd love to have, our first guest was actually Missy Mayhem, who's not on the chat tonight, was our producer, Missy Mayhem. She was our first guest. But thank you very much. Those memberships go already. They've been given out. If you've gotten one, feel free to pay it forward sometime for people. Everyone seems to love the membership. There is a whole membership section in our Justice Serve TV. And I want to tell you all that we are approaching 6 million views.
We passed it.
We passed it, 6 million views, okay? We're trying to get to 35,000. We're just a few hundred short. We're only about a year and a half old, which apparently most people don't get to 6 million views until they're in their 7th to 9th year.
5 to 7 years is the average to get that number of views. Yeah.
Unless you are, doing car things or
music videos, that kind of stuff.
Like that. So I don't know. Michael and I may have to do a music video. We're going to talk on Friday about one of the Jenners, Kylie Jenner.
For those who are claiming that Richens was clickbait, do we have anything to add to the fact that they
Walk the
Dog came in today?
Yeah, the Walk the Dog, which we've been talking about.
Look at our playlist for our extensive coverage of the Walk the Dog.
Right, and I put it up there. We have 12 videos on it. And then also what came in today is they called Carmen Lauber back to the stand. There was all this discussion yesterday about all for videos being coming in, 1,000 pages and all. And the judge finally let the defense continue the cross-examination so they wouldn't have to do of Carmen Lauber, so it looks seamless, impeaching her on whether or not she had violated any of the terms of her bail condition or parole conditions, and then the prosecution got up and did a few things.
I criticized the judge yesterday. They didn't do much but handle this issue and delay the real trial till today. But I criticized him because I felt that the defense had an argument that the prosecution wanted to effectively rehabilitate the witness through a transcript of a prior statement. Doesn't give the defense an opportunity to cross-examine, even if it was such a niggling little thing. I know I used the word you like, niggling, a little teeny thing. And the court, changed his mind this morning and allowed them to call back that witness so that there could be an entree into that subject on redirect, and then the cross-examination or recross could then handle the issues. The judge doesn't want to make that kind of mistake. It's too easy to
that's what he's trying to do, right? And
So,
Judge Mazik is very good. And so so really what they allowed was the continued cross-examination, and then they allowed the redirect. So that's really what happened. That took most of the time, and then they moved on to calling is it O'Driscoll back to the stand, going to be the last witness, and they were reading as we went on the air tonight the Walk the Dog letter, which we spent 2 days going.
We knew it was going to be the crescendo, right? The fait accompli, perhaps, for the prosecution, and now we'll see.
What is it, Michael? Why is it important for the prosecution?
Well, it's basically a confession about what she did, what she planned, how she was going to get out from under it, how she was going to alibi her way around it. You got to look at the episode we did going through this basically line by line.
Right.
She says this was part of a much larger treatment for a fictional work that she was going to do, because she was quite the author, as you know. So this 6 pages was just part of, I think, 50 or 60 pages, she says. So expect to hear that when the defense, I'm sure on cross they handled it, but now we'll find out if the defense has a case to put on. And will Kouri Richens take the stand?
And will Kouri Richens take the stand? Let's see. Let me think about the no. I can't say
no.
I think no. I don't think there's any possibility. She's gonna. They're gonna put the walk the dog letter on, and then look. They put in their case through the medical examiner, basically saying, "Well, you can't tell whether or not he took it or she gave it to him." But the fact is that they had that alcohol the night before, and then supposedly she gets into bed with him, and then she leaves to go to her children's bedroom. And look, to me, what did it? Not only that, but was that 911 call where she's supposed to be giving her husband CPR, and it doesn't sound like she's really interested in that, you know?
Yeah, you think she was purposely absent from the room so that if he started to show signs of distress,
Yeah.
she didn't have to worry about addressing it if she were laying there the whole time and he started. I don't know what fentanyl does.
Yeah, you just go to sleep. You just go
That's
to
what
sleep.
I thought. You just go to sleep and you don't wake up.
Wake up, yeah.
But she removed herself from that scenario regardless.
Right. She removed herself from that. So, will the jury have the case by the end of the week? In terms of a jury charge, will there be closings? I don't know. I don't know if it would be this week or.
And what will happen if, let's say, the defense, obviously, they've already asked for time for their motions. Attorney Lewis has already asked an attorney, the other attorney, I can't remember for the defense.
Nesta.
I got it here. Yeah, Nesta.
Kathleen.
Miss Nesta. And then
Who's
don't forget,
the lead attorney
he's kind of
for...
disappeared. But Alex Ramos, who was
I think he's
the first few days.
Yeah, Alex Ramos, the first time he was on cross-examining was just like, that was ridiculous. He's going side by side. I thought he was like doing a
performing or something.
But then he was great.
The next day he was.
It was great, and then he just disappeared.
Nothing. It's just been the two female attorneys.
Yeah.
Anyway, so they need time for their motions, obviously, and you may not have caught this. I didn't hear it till earlier this morning. The judge denied a mistrial motion.
Right.
Yeah, there was a mistrial motion
based on this whole concept of what was going to be happening with.
Yes, and he fixed it. If there was grounds for mistrial, he fixed it. So
yeah.
So we'll see what kind of defense there is. Whether Kouri Richards takes a stand, not likely, and whether they're done this week, and if they are, will they have Friday?
I think they'll have Friday off, and then maybe Monday.
Come back and start on Monday.
Yeah, start Monday with because they have to have a charge conference, and I'll start Monday with closings, and then the jury has been sitting there for a long time, and you're going to have people who are going to, remember, the defense only needs one to say, well, did the state really prove that she gave him the fentanyl, or did he take it himself?
Where it came from? Yeah, I think there's plenty of evidence where she may have obtained it. Lots of evidence about that, but getting from her possession to his intake, I think is a little sketchy.
To me, they've proven the case, but we will see. Stranger things have happened. And remember, you saw Kathleen Nestor, who is the lead attorney for the Charles Kirk assassin. So you're kind of getting a preview for how that case may be tried also in the future.
That's what I thought. I wonder what he's thinking. If he's
not what his parents are thinking. His parents are thinking. His parents, look, that case is all about the death penalty, not right? That's all about the death penalty. Yeah. That's all about, look, the parents turned him in. Are you going to try to save his life, giving him the death penalty? That's all that case is. It's like the Parkland shooting. All that case was ever about the death penalty. Quite frankly, if I were them, I think about the same type of doing the same type of defense. Plead guilty. And then go to the issue of the death penalty. That's the only way that you're going to get to save somebody's life like that. So anyhow, there you go. Whoever was upset that we don't cover Kouri, again, go to our 12 episodes in that playlist. I think we have 43 in Kelsey's playlist. There's over 1,000 videos. You can go back and watch Justice Served TV, and you can hit that subscribe, that like, that share, that notify, that comment. You can comment and then hype.
Okay, we'll see you first thing in the morning in some form, some fashion, as we get into this final pretrial hearing in the Kelsey Fitz Simmons case. So, in the meantime, have a great evening. Thanks for joining, and try to do the right thing. Wait, I'm going to try that again. And try to do the right thing.
Riding flames, they charge with mine.